Anti-defection law part 2. Issues regarding anti-defection law. Anti-party activities outside the house. Suppose there is a legislator who is engaging in anti-party activities outside the house but is not resigning and not defying whip and thus escaping action under anti-defection law. The ADL is silent on anti-party activities of this nature. Halim Committee 1998 said that a legislator is subjected to ADL when he resigns, but for anti-party activities outside the house, the term voluntary resignation in the ADL has to be defined in more refined way so as to cover the anti-party activities outside the house. In Ravi Naik case 1994, even the apex court said that the legislator's conduct from outside the house, like when he is no longer interested in the betterment of the party, he is working against the interest of the party. If not formally, he has taken himself informally outside the party. Such a conduct of the legislator can be inferred as an act of voluntary resignation, even though he hasn't submitted any formal resignation. But the problem concerning how an anti-party activities is defined still remains a matter of debate. Status of expelled members. In some cases, there may be expulsion of the legislator from the party. The reason of expulsion could be genuine due to anti-party activities or way of vendetta politics by the senior leadership of the party. Vendetta means a serious argument between two people or group which lasts for long time. And in the above line, expulsion. Expulsion means the act of expelling or kicked out of something, like club, school, or airplane. Okay. The reason of expulsion could be genuine due to anti-party activities or a way of vendetta politics by the senior leadership of the party. The Supreme Court in Vishwanathan case 1996 held that this expelled member hasn't voluntarily resigned and hence such an expelled member would be treated as an unattached member, but he will be subjected to the discipline of his parent political party, i.e. accepting whip, etc. Formally, for the purpose anti-defection law, he will be still treated as a member of parent political party. Role of speaker. Since the petition concerning anti-defection law can be filed by a legislator of the house, the problem arises that what will happen if the speaker refuses to accept the anti-defection law petition? It is the speaker's constitutional duty to accept the petition. There may also be a situation where the speaker immediately adjudicates upon the petition without hearing out all the parties and thus violates the principle of natural justice while carrying out his quasi-judicial function. The speaker has to carry out a thorough investigation and do proper fact-finding and should given an opportunity to render an explanation against the legislator against whom the petition has been filed. If the speaker feels that the issue needs a greater investigation, he can also refer to a committee, usually an ethics committee. Rajendra Singh Rana case 2007 laid out these guidelines, namely, whenever the petition is received by the speaker, he has to accept the petition regarding anti-defection law. Secondly, he has to go through a proper investigative process, like an opportunity to the defendant to explain himself to the opponent, to file proofs regarding defection and henceforth take a decision. There is an important issue with respect to a speaker's role. Whenever there are genuine cases of defection where the speaker should have taken immediate decision and disqualified them, the speaker has made inordinate delay in arriving at the conclusion and has done floor management to preserve the interest of the political party in power. Here, floor management means person in charge of a floor or department of a large shop, a person assigned to direct the proceeding on the floor of an assembly. This is because anti-defection law does not talk about any time frame within which the decision should be taken. Occasionally, the courts have directed the speaker to decide the matter within a fixed time frame. Ideally, a norm should be codified in the ADL where very case should be decided within a span of 3 months. Another problem is that if a matter of defection goes to the court, even the courts don't have a fixed time frame to decide upon the issue. The Supreme Court has laid down the norm that if an anti-defection law petition is laid before the courts, it has to be decided within 6 months. Note: Australia, Canada, France, UK, Germany do not have any penal provisions concerning defection, while South Africa, Bangladesh, Kenya, Singapore have some sort of penal provisions for defection. Views of the NCRWC. The National Commission of the Review of the Working of the Constitution has set up under Justice M.N. Venkatacharya in 2000 to examine the functioning of the Constitution, which gave its report in 2002. It recommended the cap on the number of legislators in the Council of Ministers, 15%, was placed after the NCRWC recommended a cap of 10%. The defector should be barred from holding public office or any remunerative political post for the duration of the remaining term. A case may arise in certain situations where the defeated legislators are not disqualified from the House and subsequently participate in the no-confidence motion against the government. Then there may arise instability in the government, which anti-defection law tried to prevent. NCRWC tried to prevent this by recommending that such votes should be declared invalid, as such a provision is not there in the anti-defection law. Though the courts have come to rescue in such cases of floor management, such norms should be placed in the anti-defection law itself. The vote cast by a defector to topple the government has to be treated as invalid as recommended by the NCRWC. Views of Law Commission. The Law Commission recommended that the provision that exempts merger and splits must be deleted. Say a legislator from party A contests the election and win. Few months she decides to switch to party B, which is opposition party. Anti-defection law violation. So here is clearly anti-defection law violation. However, if a party A has majority in the House, they may choose not to disqualify the legislator as it could affect the majority status in the House. In such a case, legislator would not be disqualified from the House but may face other consequences such as a loss of party membership or privileges. Next, it also suggested that anti-defection law should also cover pre-poll alliances. Issues with anti-defection law. Even though many steps have taken to prevent defection, they happen anyway. Defection is principally a result of ethical deficit in our political culture. If a legislator is ready to leave his/her political party on the basis of some allurement, then the problem is political culture and the ethics that has dipped in the political culture. An illegal addition to the anti-defection law tries to solve any ethical dilemma with a legal intervention. The ultimate solution will be maturing of political culture that frowns over such things and does not support such actions of their leaders. Another issue is that defection proceedings happen only when a person goes up the membership of the party and not when he resigns from the seat or the membership of the house itself. Such candidates later switch parties, contest by elections, and do not invite any defection proceedings onto them. Ethical dilemma means is a conflict between at least two ethical principles, both of which could lead to an equally good or equally bad outcome. In such situation, obeying one principle leads to transgressing another, whereas both principles seem equally valid. Some parliamentary terms associated with anti-defection law. Crossing the floor. Inspired by the British House of Commons, where two parties sit on either side opposite each other, namely the ruling party and opposition party, and thus the term means changing party loyalty. Holding the floor. The act of speaking on the floor of the House with the due permission of the Speaker. Yielding the floor. The act of Speaker of the House to make a person stop speaking and allow someone else to speak in the House.